And on today's show, how the biggest estate planning mistakes can destroy equity built over time. Part 2 of this week's series on estate planning update for 2015 with author and top producer Mike Kilborn, CLU CHFC. Hi everyone, I'm Steve Savine, syndicated financial columnist and contributing author to Innsmark, Life Specs, and Backroom Technician. Let's get down to business. Well, welcome to the show, Mike.
Oh, thank you.
Well, day 2 with Mike Kilborn, we're talking about a major top-of-the-table producer who really does serious work. We're going to talk about his book in the second segment. I really want you to really think about this. A lot of people think, hey, estate planning's dead because, hey, why should I even talk about it if the client's unified credit isn't over 10.3? But we are talking about a lot of issues that have nothing to do with the unified credit.
That's true.
So let's talk about this idea. Biggest planning mistakes. When I hear that, I get nervous because we have client. We talked about this yesterday. There's people that aren't using the bypass trust, and they're exposing their estate to undue taxation.
That's correct.
So talk about some of the biggest ones you've seen.
All right, well, one of the first ones is procrastination. I mean, quite frankly, last year, 55% of the people who died in this country did so without a will, without a trust, without any planning. So their families had to rely on something what's called intestate, which is the state's plan. And I'm sure the people that died without planning would turn over in their graves if they knew how their assets passed according to the state's plan.
Wow.
So first, that's what you want to look for. Clients almost always will say, well, yeah, I've got a will out there somewhere, but the wills may be way antiquated, may even provide for a former spouse. I mean, they really have to be looked at. That's one, but there's another one, and this probably, sometimes I push this way up to the top, and that is failing to fund a revocable living trust. Now, revocable living trust is a document that is so simple. You transfer assets from yourself to yourself as trustee, and your life goes on. In fact, if you want to put it back from yourself as trustee back into your name as an individual, you can do that. But in any event, life goes on, and it's simple. But if you fail to put assets into the trust, then you will have probate on those assets that you left out.
So you need to account for every asset you have. Is that what you're saying, Mike?
That's right. There are some that don't go in there, like an IRA and some annuities. But generally, most things go into your name as trustee of your revocable living trust. That's a big one. Wow.
Well, I'm looking at your list here, and I mean, when you're thinking about owning life insurance, because a lot of this can really help us in our tactical approach to not paying the IRS anything more than we have to.
Right.
But when you talk about it, you say there's a mistake here. They're buying life insurance. Why is that a mistake?
Well, it's not that you shouldn't own life insurance. You should have life insurance. You just shouldn't own it in your own name. The one that owns it controls it. And essentially what it means is it'll land up in your estate being accounted towards the taxable part of your estate. For example, let's say you had an estate that was $5 million. And the exemption we know rounded is $5 million, okay? So there's no estate tax, except that maybe you have a $2 million life insurance policy. Okay, now you die and you own it. And you die, well, unfortunately, even though the $2 million goes to family members, it's counted in your estate. So now $800,000, that 40% of the $2 million is going to go to Uncle Sam. You just wasted $800,000 because you owned the life insurance policy.
Now, let me ask you this now. How many times do you see that? Is that prevalent?
I do see that a lot. In fact,
you do? Wow.
It's amazing that people don't understand. Well, I won't say a lot. I see it. And when we see it, we grab right away. We say, no, this is wrong. And somehow or other, we have to get it into an irrevocable life insurance trust or into ownership by the heirs.
I'm looking at this next one, lack of liquidity. I mean, people do not fund the liquidity for the end of their estate to kind of get the transfer going and all this. What's with that?
I mean, I had a client I was thinking of. He had nearly $20 million estate, but almost all of it was in real estate. And at death, guess what? Someone's going to have to do a fire sale on some of that real estate to pay the enormous tax. It's about a $6 million tax because you figure $20 million, use $5 million exemption, that's $15 million, 40%, you've got $6 million.
I noticed here that you use this phrase, and I've never heard this phrase and maybe this is one of your own proprietary phrases, but you say there's a lack of a master plan, some overall canopy document that really directs traffic here.
Well, it's not necessarily one document, but it might be a handful of documents, and we can certainly make a simple arrangement. A revocable living trust and an insurance trust might be all that you need, but not visiting your plan every 2 or 3 years, that's a mistake. As I said, it takes, the typical time is 19 and a half years before people revisit their plans, and when we see that sort of thing, we see all kinds of holes in it, and we plug them. Like the person that had an insurance policy that was payable to a former spouse that he was divorced from, and didn't know it.
It's amazing to me in this age of knowledge and internet information that people are not using their exclusions, their deductions, and exemptions.
Right. I mean,
Mike, I'm stunned by that.
Well, think about it for a second. You say, well, all right, there's only 2 reasons you would not want to use them and make gifts within them. One is we don't want the kids to have it right away, and I say, fine, I don't believe you should give it out right anyway. Let's put it in trust. Well, yeah, but I might need it, or we might need it, the assets that we would put in there. Fine, let's create the trust and have your spouse be the trustee and an income beneficiary, so that if you need those assets back out, your spouse can get them out. And so there are ways, but not using your exemption is wasting those exemptions. For example,
you even talk about not leveraging it.
Yeah, leveraging now.
There's misleverage here.
Well, then you take those, so you make the gifts perhaps to a trust. Why not buy life insurance or invest in the market in some way so that there's a lot of growth inside that trust? Because once you've made the gift with your exemption, everything inside is still exempted from gift and estate tax. So if it grows to $500 million, it's all exempted from gift or estate tax.
We come back from the break. We're going to continue in looking at Mike's top of the, we're talking about top 10 here, biggest estate planning mistakes right after the break. It's not how much money you make for your clients, it's how much money they get to keep, especially in retirement. But retirement income could cause Social Security benefits to be taxed. One tax advantage alternative is life insurance designed as a non-modified endowment contract that can generate tax-free income without taxing Social Security benefits. These contracts offer differing funding options depending upon your client's risk tolerance. For more information on how life insurance can be part of your retirement planning, just email me at steve@downtobusiness.tv. Brought to you by Ash Brokerage, the practice enhancement company. Well, welcome back to our second segment. Of course, we're with Mike Kilborn, not only platform speaker, not only a huge top producer at the top of the table, but a major author. This is what, your third edition of Inherit the IRS, Disinherit the IRS?
Yes.
I love this title. You can even go out to Amazon.com. You can go to Mike's
at disinherittheirs.com.
Yeah. Those two sites to pick up this book. To me, I really recommend it because even though it looks like an anthology, and believe you me, it is like an encyclopedia, Mike does it in a very easy to understand English format that I really think that if you're going to be into the things, some of the ideas we're talking about throughout this week, this book will really help. So you can go out to those sites and hop out there and read it.
Thank you. In fact, at the beginning of each chapter, I've got little stories of a case that you can read. They're short, and it talks about how, and that leads into the strategy that they use.
Well, Mike, let's pick up. I want to talk about this. This one stuck in my head, I have to say, of the entire list. Choosing an inappropriate executor or trustee.
Oh, boy.
Oh, my gosh. How prevalent is that?
Well, I see it, I won't say often, but I see it now and then where, a parent died and left everything in control of one of the siblings. And I remember talking to a lady who said her two brothers hated her. And I said, why on earth is that? She said, well, because I'm in control. I make the decisions, and they're always begging me for money. And I'm thinking, well, I really would not, I would have consulted them in another way, perhaps to divide into separate trusts. And if you're worried about the spendthrift nature, then I would have had a co-trustee arrangement. But the inappropriate trustee or executor can really mess up.
Now, you're not only that, but you talk about some of the basic incorrect beneficiary designations for IRAs, qualified plans. I mean, there's some real mistakes being made here.
Oh, absolutely. I mean, what's nice is that you can, if you do it right, you can make it so that your heirs can basically disclaim. What does that mean? Well, they can sort of step aside and let the funds that would have gone to them go to perhaps their children, your grandchildren. But you have to name them. In other words, you have to put the stones in place before you die, so that after you die, changes can be made to some extent.
If this isn't done right, is it correct? Can you correct it?
Well, if you can't correct it after death, so you have to correct it now. So you put the stones in place, and so you look at your beneficiary. Have your clients look at their beneficiary designation forms to see how who the heirs are and who they've got as backup.
Now, I notice that a lot of people, and you seem to remark and make sure I understand you correctly, a lot of people own their property jointly.
Oh boy, and that turns out, in my opinion, to be a big mistake. Owning property jointly seems like a simple plan. You die, everything passes to the joint owner. What's done? There's no probate, just goes.
Right.
Well, yeah. Well, all you've done is delay it to the probate to the second death, if you're passing to a spouse, for example. Thirdly, it oftentimes passes assets to unintended heirs. I mean, what if your spouse remarries and then dies immediately? What about the new husband and the new husband's children or heirs?
You really have to forecast a lot of assumptions and predict possibilities here, don't you?
Oh, absolutely. I mean, you have to. With joint ownership, there's no planning opportunities. There's no control. I mean, it's out of your control, so to speak. And by the way, it's excellent for creditors. I worked with a really good attorney who had a client who hit a school bus, and it killed some cool children, and it killed him. And they sued the client, and he held the car jointly with his spouse. They cleaned her out. They took everything, and she wasn't even in the car. And they took everything they had because they had that car jointly. We think that joint ownership is a big mistake. There's gift and estate tax implications. I had a wonderful neighbor, Louise, and Louise lived to 98 and a half, I believe. I met her when she was 80. She lived to 98 and a half. But during that time, she bought a condominium and put it into her daughter-in-law's name, her stepdaughter's name, and her name. And oh my God, she created a huge gift and didn't know it. She did the same thing with her car. And boy, when I found that out, boy, didn't I back her off of that.
So there's issues about joint ownership of assets that you have to be, one could be liability on the civil side of that issue, and then you're talking about tax liability.
Right.
Okay, now what about this contingent about, you talk about failure to consider digital assets. I've never heard that phrase used in estate planning before.
Well, right. In fact, people don't realize that they have a lot of things now today, in this modern world, are all stored in the computer. And so they should have all those passwords and code names, usernames, all put somewhere so their heirs can get to it. If not, maybe their attorney, somebody could get to it.
Now, I noticed that, because we live in a very, our culture has changed. The baby boomer generation, which you and I are part of that, Mike, I mean, most people have divorced. 60, 70% of our generation is divorced. You really want a divorce contingency in your overall planning scheme? I
want a plan, yes, I think it should be built into the plan in various ways as between my client and his spouse, but beyond that, what about their children getting divorced? In fact, in today's society, I think the number is something close to 50%. And if that's true, it's like flipping a coin. So why wouldn't you build in something to protect your children? And as I said in an earlier show, what we do is we leave it to your children in trust. And now, if they end up getting divorced, that won't enter into the divorce settlement.
So I have to anticipate that in case this does occur, even if I've been married a long time, you and I have been married 40 plus years to each of our gals, but we still need to have a contingency plan.
Well, which, for example, you build into a trust arrangement for your spouse. Say you die, your spouse gets it. If that spouse gets remarried, you want her, perhaps, or him, to have a premarital agreement with the new spouse. And if they don't get one, then maybe the assets don't come out of the family trust that they would have otherwise received. I mean, we build that into a living plan while they're alive.
Well, that's all the time we have for today. Remember, before moving forward with any of the ideas on our show, always consult your tax advisor, legal counsel, or your broker-dealer compliance officer. Missed an episode? Just go out to our video archives. And remember, you could be wiser as an educated advisor. I'm Steve Savan. We'll see you tomorrow.